Welcome back to the Constitutional Clarion. Today I'm going to address the controversial topic of the relationship between laws that prohibit Nazi salutes and the implied freedom of political communication. Now, what provoked me to talk about this was some media articles yesterday about the case of a Melbourne man who is the first person to have been charged and prosecuted in Victoria with allegedly performing a Nazi salute in public, in fact outside a court. Now, the articles noted that his case had been delayed because his lawyer had issued a Section 78B notice, and this caused some confusion amongst the community. So, a Section 78B notice is a notice that's issued to the federal and all the state attorneys general saying that a constitutional issue is going to be raised in the case, and it gives them the opportunity to make submissions and intervene in the proceedings if they want to, because constitutional matters are of great importance to all the parties to the Federation. But what might the constitutional issue be in this case? Well, first of all, we need to look at the relevant legislation. So, Section 41 K of the Victorian Summary Offences Act of 1966 was inserted in 2023, and it makes it an offence for a person intentionally to display a Nazi symbol or perform a Nazi gesture, and that includes a Nazi salute. And they have to do it in a public place or in a school, either a public or a private school, or within sight of one. So there's an element there that it has to be something that can be seen from a public area or a school. Now, there are, of course, a number of exceptions, as you would expect, including for acts done reasonably and in good faith for a genuine academic, artistic, educational or scientific purpose, and also for reporting on a matter of public interest. So, for example, if the media showed footage of people marching and making Nazi salutes or with Nazi gestures, then that would be an exception. Now, a Nazi symbol of gesture can also be used if it is done reasonably and in good faith in opposition to Nazism and fascism. So say, for example, you were at a protest and you had a placard up which had a Nazi swastika with a big cross through it, rejecting it. So that sort of exception exists as well. Now, the maximum penalty for breaching this law is a fine of 120 penalty units, so that's about $23,000, or imprisonment for 12 months, or both. Now, if it were a Commonwealth law, the first thing that one would do would be to have a look to see whether it falls within a head of power that had been conferred upon the Commonwealth Parliament by the Constitution. But in this case, it's a state law, and there's no need to search for a state head of power. States have power to make laws with respect to absolutely anything, as long as it's not a subject that the Commonwealth Constitution has actively withdrawn from them. And that's not the case here, so yes, a state can make a law about that kind of thing. Now, if the state law was inconsistent with a Commonwealth law, then the Commonwealth law would prevail, and the state law wouldn't be invalid, but it would be inoperative to the extent of that inconsistency. And that's set out in Section 109 of the Constitution. Tricky issues can arise when both the Commonwealth and state laws prohibit a particular kind of act, and they have different defences or other conditions involved. Now, in this case, while the Commonwealth has since also prohibited Nazi salutes in legislation that came into effect in January of 2024, this particular prosecution occurred in relation to an alleged Nazi salute that happened well before that in Victoria. So at the time, there was only one law applicable, and that was the Victorian law. So no inconsistency problems here either. So it's likely that the constitutional issue therefore concerns whether the state law breaches the implied freedom of political communication. Now, this is an implication that's derived from the Commonwealth Constitution, but the High Court has held, first of all, that political communication is itself indivisible, so you can't divide it off between communication about state matters and Commonwealth matters, and also that the implied freedom of political communication in the Commonwealth Constitution can affect the validity of state laws as well. Now, the first thing to know about this implied freedom of political communication is that it is not a positive right. It does not give anyone an individual right to make a political communication. Instead, it's an implied limitation on the power of the relevant parliament to make the law that prohibits or limits that kind of political communication. So the question is whether the particular law under which a person is being prosecuted is invalid because it breaches the implied freedom of political communication. The focus is therefore on the relevant law and its validity, not upon what the person actually did. The second thing to know about the implied freedom is that it is not absolute. There are many laws that limit freedom to communicate on political matters, such as defamation laws and laws concerning contempt of court, which remain valid because they satisfy the relevant test that has been laid down by the High Court. Now, what is that test? Well, the terms of it keep being changed or twiddled by the High Court from time to time, but the gist of it at the moment is that it has 3 limbs to it, and in those 3 limbs you're asked a particular question. So, it goes as follows. Question 1. Does the law effectively burden the freedom in its terms, operation or effect? 2. If yes, is the purpose of the law legitimate in the sense that it's compatible with the maintenance of the constitutionally prescribed system of representative and responsible government? And 3, if yes to that, is the law reasonably appropriate and adapted to advance that legitimate object in a manner that's compatible with the maintenance of the constitutionally prescribed system of representative and responsible government? Now, in assessing that last question these days, at least a majority of the court says that you must then decide whether or not the law is suitable, necessary and adequate in its balance. And that's known as a system of structured proportionality. Now, all that might sound like a lot of gobbledygook, I do appreciate. So what I'm going to do is just work through this as like an exam problem, for example. Hopefully no one set this as an exam problem, but anyway, I will work through this to try and explain to you how it operates. So, does a law that makes it a criminal offence to perform a Nazi salute in a public place or a school breach the test? So the very first limb of the test asks whether the law effectively burdens the implied freedom. So does it prohibit or constrain a person from making a political communication? Now here we have a gesture, a salute, rather than a written or oral communication. So does that count? Is that affected by the implied freedom? And the High Court has said yes, it does. Symbolic speech can also be a way of communicating political messages. In the Levy case, which is a case that concerns duck shooting laws and whether Mr. Levy was able to make his political point by piling up the dead carcasses of birds that had been were endangered and had been unlawfully shot, so a visual image. The High Court held that the implied freedom protects non-verbal communication of political matters. So Justice Kirby, for example, in his judgment, said that lifting a flag in battle, raising a hand against advancing tanks, wearing symbols of dissent, and participating in a silent vigil were all forms of political communication. As distasteful as it is, lifting an arm in a Nazi salute is also a form of political communication. And this law would burden the freedom to make such a political communication by prohibiting it. So that's the first limb of the test satisfied. So then we go to the second part. is there a legitimate purpose for such a law that is compatible with the constitutionally prescribed system of representative and responsible government? Now, looking back at various cases in the past, the High Court has described as legitimate purpose things like the right of individuals to live peacefully and with dignity, the protection of the community's sense of decency, and the protection of people from intrusion of seriously offensive material, particularly where that material was posted to their home. But when the High Court has dealt with laws that prohibit offensive or insulting communications or conduct, such as the cases of Coleman and Powers, which concerned insulting police, and the Monis case, which concerned extremely offensive statements made to the parents of deceased members of the armed forces, the court has tended to interpret the scope of the law in a very limited way. And this is known as reading the law down. Now, this is to limit it so that it only applies to the most serious levels of offensive conduct in order to try and make the law valid. So serious offensive conduct would include laws that are directed at hurting identified persons or are intended to provoke an unlawful physical retaliation, so provoking violence, or those that are likely to arouse significant anger, resentment, outrage, disgust, or hatred in the mind of a reasonable person in the circumstances. Now, a Nazi salute is likely to fall within this category of highly offensive material. It may indeed provoke violence, and it would be likely to arouse at least outrage and disgust in the mind of a reasonable person in the circumstances. So it seems to me likely that the purpose of prohibiting that conduct probably would be regarded as a legitimate purpose under the second limb of the test. So this then brings us to the third limb of the test, which is about proportionality of the law to its legitimate object. And this is the most difficult part of the test. It's mainly where you find the fight when it comes to the implied freedom of political communication. Most of it comes down to this final limb of the test. In the past, the court has been divided over the proportionality of laws that deal with seriously offensive or insulting forms of communication or conduct. So in the Monis case, the court was actually evenly split, with 3 judges finding that laws prohibiting even really seriously offensive political communications were still disproportionate and therefore invalid, whereas 3 other judges found that they were proportionate and valid. The court's findings often turn on the detail of the law, what exceptions there are, what defences exist, and how narrowly it is targeted to achieve its object. Now, it's anyone's guess as to how a court would apply the test here in terms of prohibiting Nazi salutes. My guess, for what it's worth, is that the validity of the law would probably be upheld because the law itself is quite narrowly focused on a very specific form of conduct, not offensive conduct generally. But as always, it will of course depend upon the detail of the law, the arguments that are put to the court, and the weight that each individual judge places on the importance of freedom of speech compared to the importance of protecting the community from being exposed to seriously offensive gestures. Now, I hope you found this useful as an attempt to explain what the constitutional issues behind this case are likely to be and the issues that are going to be raised in them, and how it's actually quite a bit more complex than may be suggested by media headlines. Thank you for watching the Constitutional Clarion, and I look forward to seeing you next time. Goodbye.